Sometimes we have a case where I go to my client and I say, listen, there is no legal basis, unfortunately, for a judge to just dismiss the case at preliminary hearing because, unfortunately, the prosecutor only has to prove this much of their case, really. They only have to prove that there's probable or sufficient cause to hold your case over. They only have to prove that it's worth potentially putting in front of a jury, not that you actually are guilty. But by virtue of doing the preliminary hearing, you might be doing yourself a favor, depending on the case. Because when you force the DA to bring their witnesses out there, you expose them to questioning. And when you do that, you and your lawyer get to ask them questions and really highlight weaknesses in the case. It's important to know that as you're sitting through your preliminary hearing, you're hearing a lot of bad things being said about you. You're being identified as having committed a crime. But again, get through the preliminary hearing with your lawyer and let them flesh out the weaknesses in identifying you as the actual doer. Even though the case is not going to get dismissed at a preliminary hearing, there might be another approach to it. And that's where this long game strategy comes in. To watch the whole video, click here.